Stand by, Greg.
Okay.
Go. Go.
Oh, hello, everybody. First off, I would like to say thank you all for coming out to my estate planning event. And I would just like to say thank you to Tuskegee University for allowing me to present this information to you all. This is a topic that estate planning, which is a topic that's very near and dear to my heart. Um, my name is Gregory Elliott. Gregory Dash. I am a 1998 graduate of Tuskegee University. I'm also a computer programmer, which computer programming afforded me the opportunity to attend University of Baltimore School of Law, where I obtained my law degree, and now I'm an attorney. Been an attorney since 2013, and I have my own law firm, Dash Law Firm, which we practice the areas of estate planning, family law, and criminal law. So I don't know if I can control this. I don't see the PowerPoint. But anyway, so what you okay? I still don't see it. These so I usually have these events in person, and they're usually very interactive. So people ask me questions while I do these throughout, and I do these throughout the state of Maryland. And the reason I do them is because, again, I'm very passionate about estate planning, because this is an area of law that our people are not taking care of, and it's causing a lot of problems in our community. But like I said, I usually do these interactively, but we have a different format. And so I'm going to go through a few sections of or different areas of estate planning, and then I'm going to answer any questions that you all may have after I finish a section. Because there's a timer on here that's counting down, and I don't know what happens when that timer times out, so I don't want to see what happens. So again, I'm passionate about this area of law, estate planning, because it's an area of law that we are not taking care of, and it's causing a lot of issues in our families. I mean, in our community, I should say. And I really want to make sure that we all get this estate planning documents put in place. I don't care how you get it done. I just care that you get it done. And I just want to start off saying that this is not legal advice. This is only information about estate planning. And just keep in mind that no two situations are the same. And I do this because I believe in educating our community, and that only means that I believe in giving information about a topic that you all may not know much about. And I can be reached if we run out of time, or if you have any questions outside of this. I can be reached at g-at-dashlawfirm.com, or my cell. You can text me or call me anytime at 443-622-6523. So the three main areas of estate planning that I'm going to discuss today are wills, powers of attorney, and advanced medical directives. Those three documents cover around approximately 95% of most people's estate planning needs. I'm also going to touch on trust, because I get a few questions about trust as well when I do these seminars as well. All right, so why is estate planning so important? I'm not a preacher. But I do read the Bible. And one thing I know for sure is that we are all going to pass. Passing away is inevitable. The only person that didn't pass away, according to the Bible, was Elijah. In 2 Kings 2, verses 1 through 12, he was actually just taken off the earth. But for the rest of us, passing away is inevitable. Matthew 24, verse 36 says, "But about that day or hour, no one knows, not even the angels in heaven, nor the Son, but the Father God." And although that verse is actually referencing when Jesus will return, that also applies to our lives, because none of us knows when that time is going to come. But so passing away is inevitable. However, preparation is key, and also control is the key. So you'll hear me say that term control throughout this seminar because that is something that we can control. We can control certain aspects of our lives, which is estate planning. But this is not all about doom and gloom, because many of us are either beginning to accumulate or have accumulated wealth throughout our lives. And so we want to ensure that we control the proper transition of our legacy. And we do that by taking control of ourselves, our property, and our offspring while we still have the chance to do so, both while we're still alive and when we transition. So again, remember, the key word control is the key. And so I'm going to start the discussion off by discussing wills. And there are a few parts of a will: a testator, a personal representative, or executor designation. Executor is a term that's used in other jurisdictions. We use the term personal representative here in Maryland. Probate asset designations and guardianship designations. So the testator, what is a testator? The testator is the person for whom the will is being drafted. And that person has to be 18 years of age or older, because a will is governed by contract law, and contracts that are created with a person that's under the age of 18 are either invalid or voidable. So the testator has to be of the age of 18, and that person also has to understand the provisions of the will, and that person has to ensure that the will disposes of his or her property in accordance with his or her wishes. So that person has to be coherent and cannot be an incapacitated person. So at times I get people that come to me and say, my mother, she told me what her wishes are, but she's going through dementia or has some type of incapacitating condition. And I say to them, well, there's nothing we can do about that, because the person has to be coherent and cannot be incapacitated in order to establish a will for that person. And then, so a will here in Maryland and in most jurisdictions, a will only has to be signed by the testator, and the signature has to be witnessed by two other witnesses. Another aspect of a will is a personal representative designation. And right now I can't really see if you all are putting anything in the chat, but I will check the chat to see if anybody has any questions after I finish discussing about wills. So another aspect of a will is a personal representative designation. And a personal representative, or the executor, is the person that will execute the will. So that person must have the ability to carry out the financial transactions and administrative tasks of an estate, and opening an estate as well. And they have to ensure that the wishes of the testator are followed. So that is a person that has to be a responsible person and a trustworthy person, because that person has the responsibility of gathering the assets of the testator into the estate. They must make reports to the Register of Wills in the county. They must pay the debts and the taxes of the estate, and they must distribute the assets based on the provisions stated in the will. So that person has a very big responsibility, and that person needs to be a very trustworthy person. I had a situation where a person came to me after their sibling passed away, and one of the other siblings was the personal representative. That person, the personal representative, had a will for the deceased person, but they didn't turn that will in, or they didn't produce that will, because the will didn't include that person's daughter in the will, and he felt as though it should have. And so I had never seen a situation like that before. So I did some research, and I learned that there are actually criminal penalties for a person not producing a will, and there's civil penalties as well. So it's very important. That person needs to be a very trustworthy and very responsible individual. And so another aspect of a will is the probate designation, probate asset designations. So what is probate? Probate is the official act of opening a will. And the will controls the disposition of probate assets. So, what are probate assets? Probate assets are assets that can be gifted to another person when a person passes away. And probate assets include assets that are titled solely in an individual's name. So it's not jointly titled assets. It's assets that's titled solely in a person's name, and they include assets such as a bank account, stocks and bonds. They also include tangible personal property such as jewelry, boats, vehicles, collections. You know, we have baseball card collections. All of that is considered probate assets as long as this is titled solely in an individual's name or it's owned solely by an individual. Real property also is included in probate asset as long as that property is titled solely in an individual's name. So with regards to real property, we have property titled in different ways here in the United States, actually. And one way is joint tenants with rights of survivorship. There's tenants in common, and then there's what's known as tenants by the entirety. Tenants by the entirety is a provision that's stated just for or reserved just for married people or married couples, and it is designated in a way that only the spouses own the property. Neither one of the spouses owns the property outright. They both own the property jointly, meaning that neither of the spouses can dispose of or transfer that property to anyone else without the consent of the other spouse. So that's considered joint property, and that type of property is not considered a probate asset. And once one of the spouses passes away, then the other spouse owns that property outright, and then that property then is now solely owned, and that the still living spouse, and that living spouse can now that property is now considered probate as a probate asset. I mentioned tenants in common. That's another title of property, meaning that a person owns a percentage of a property jointly owned with someone else. That percentage of property that person owns is solely owned by that person. So that type of property is considered a probate asset because it's owned solely by that individual. And so I mentioned that jointly with rights of survivorship, similar to tenants by the entirety, that's another title of another way of titling property that's jointly owned by various individuals. That type of property is not considered a probate asset because they all own this property, and no individual can do anything without with that property without the consent of all the other owners. However, in that instance, in that situation, when all the other owners pass away, the last person that's still living now owns that property outright, and that person can then devise that property because it is considered probate property at that point because now it's owned solely by that individual. Okay, hope everybody's all right. So I'm going to move on. So what are considered non-probate assets? Non-probate assets are assets that are jointly titled assets with rights of survivorship. Because again, that property is not owned solely by an individual; it's owned by all the entities involved, and that property is a non-probate asset. Assets that have a beneficiary designation are non-probate assets. So life insurance policies, IRAs, retirement accounts, those types of accounts that have beneficiary designations, those types of assets are non-probate assets as well and cannot be devised of in a will. Another type of asset that is a non-probate asset is a pay-on-death account. This is a special designation for bank accounts where you signify to the bank that I own this bank account, and upon my death, the money in this account goes to my beneficiary that is designated as the pay-on-death designee. So that is considered a non-probate asset as well because it has a beneficiary designation. So another aspect that a lot of people may not know about that wills cover are guardianship of minor children. And a guardian is a person that's designated to care for a minor child. The natural parents of a minor child are automatically considered the guardians of their minor children. However, if the natural parents are no longer alive, then the courts will decide who is the guardian of the minor children. And the courts will give deference to a designation that's made in a will. So we need to make sure that we take care of those designations and put them in a will. You hear a lot of terms in our community. A lot of times in our community, you hear a lot of people say, "I am a godparent," or "These are my godchildren," or "That's my godfather," or whatever. Those terms do not mean anything in the eyes of the law if it's not in writing. And the place to put it in writing is in your will. So these are very important documents that we need to get taken care of, because if it's not in writing, it means nothing. Even though we might say it, we might think it means something, but it doesn't. Um, so there's certain special conditions that occur that 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 occur when we need to make updates to our documents. If a person, or if the testator is remarried, becomes remarried, then the testator, that person needs to establish a new will. If the new will is not established, then the previous will be followed, and it might not necessarily go, or might not be designated in the way that the person really wants it to be, or it might not be designated in the way that their new spouse wants it to be either. So that might cause problems in the family. Also, if a testator is divorced, the divorce revokes all provisions pertaining to the spouse, unless there's documentation in the will otherwise. So if a person gets divorced, they need to update their will as well, or that can cause problems in people's families as well. A new will revokes any and all previous wills or codicils. And a codicil is nothing but an add-on or a modification or addition to a previous or a will. And anytime you create a new will, the old will needs to be destroyed. So people also put funeral provisions in wills. I recommend against that, because oftentimes when a person passes away, the will is not brought forward, sometimes days, weeks, even months after a person passes away, and it might not be brought out in time for a person to know, or for the family to know, what that person's funeral provisions actually were. So there are next slide is like about notable people that have passed away without having a will. And you probably recognize most of the people on this list, and you probably even heard some of them in the news. Martin Luther King, he passed away in 1968. However, his family is still having issues dealing with some of his property and designation or disposition of his property, because he did not have a will. And Jimi Hendrix, Bob Marley, Steve McNair, the quarterback for the Titans and the Ravens, he didn't have a will when he passed away. Prince Rogers Nelson didn't have a will. President Abraham Lincoln, Aretha Franklin, you all probably heard in the news about Aretha Franklin not having a will. And then more recently, Nipsey Hussle did not have a will established when he passed away. And this is actually causing issues in his family right now, because the mother of one of his children is actually trying to establish guardianship over that child, but the parents are not in agreement. So they're having issues with that as we speak, actually. Chadwick Boseman on Black Panther did not have a will established. Anthony Johnson, who was Ezel from the movie Friday, did not have his estate planning documents in place. And you probably saw in the news that his wife was actually trying to establish a GoFundMe account to have him buried, because he didn't have. And this could have likely have been avoided had he had his estate planning documents in place. And then lastly, rapper DMX, who had a number of children, did not have his will established, and so that might be causing a lot of issues in his family right now. So these documents are very important. This will is a very important document. Once you establish that document, I always tell people to put them in a safe place. I actually tell them to put it in a safe within their house, so that, and make sure that the personal representative knows where this document exists, so that when that time comes, that they can it's readily available for that person. I know people used to put them in safe deposit boxes in banks, but I recommend against that sometimes because banks have been turning over and new banks have been taking over what old banks have been doing, and sometimes it causes issues when you try to access your safety deposit box. But if you have it in your safe in your home, you readily have access to it. So that pretty much ends the discussion on wills. I don't know if anybody had any questions about wills, but if not, I'm going to keep going forward to speak on or move on to powers of attorney. Okay. So the power of attorney, that document, this is a very, very, very important document. It grants another person to perform financial transactions on behalf of an individual. And so in essence, that person is actually you. So once you grant somebody the power to be an agent on your behalf, that person can do everything that you can do. So there needs to be again a trustworthy person and a responsible person, because it grants the principal the power to select someone to be the agent and handle their financial transactions. This document can be made effective when the principal decides, or when the doctors determine that the principal is incapacitated. But when I create these documents, I always make them effective immediately, because it leaves out the I guess it leaves out the fact that somebody else has to make a determination of the incapacity of a person, and that could be subjective, and it could take a lot of time. And in the meantime, these financial entities still have to be paid, or still want to be paid, because oftentimes they do not care. They don't have the compassion to care about the fact that somebody's incapacitated. They oftentimes just want their money. And so, just also a power of attorney, it terminates upon the death of the principal, or when it's revoked by the principal. So a lot of people come to me about establishing a power of attorney after the fact. So a person becomes incoherent or incapacitated, and then someone comes to me and says, my mother is. I had somebody call me recently and say my mother is ill. She is suffering from dementia and no longer can sign and recognize what's going on. But and I don't have, and that person, they say I don't have access to her accounts, and I don't have the money to pay for her financial transactions. So I need to establish a power of attorney so that I can get access to her her bank accounts and all. And I tell them, it's too late, really. Unfortunately, that you cannot establish a power of attorney for a person that's incapacitated. The person has to be coherent in order for the power of attorney to be established. So there are consequences to not having a power of attorney should a person, God forbid, become incapacitated. And those consequences are financial. Again, these financial transactions still have to take place. These financial entities still want to receive. The mortgage company still wants their money. The car loan company, they still want their money. The bank, the credit card company, they all want their money. So these financial transactions still have to take place. And if we don't have these powers of attorney documents in place, it could lead to the loss of possessions, which would be devastating, because a lot of us have worked extremely hard to accumulate or establish a lot of this wealth that we've established while we're here. I had a situation where a grandmother, this granddaughter of a grandmother, took her grandmother in, but didn't establish a power of attorney. And so the grandmother became ill and incapacitated, and the state actually took on guardianship of the grandmother. And so this once the state became a guardian of grandmother, the state started spending the grandmother's money out of the grandmother's account based on the way that the state felt as though it should have been spent. And this caused a lot of problems with the granddaughter because it wasn't being spent the way that the granddaughter or the grandmother would have wanted it to. And so if she would have had this power of attorney document set in place, she would have been able to take care of these financial transactions for her grandmother. I mean, there's numerous stories about the importance of all of this estate planning document, but these are some of the more recent ones that I've had. Uh, right, I think I just mentioned I had a guy come to me about his mother. She became ill, and he wanted to establish a power of attorney, but I explained to him that it's too late. So we need to do all these. We need to establish all these estate planning documents while we are coherent and while we are not incapacitated. Uh, uh, and so, in order for a power of attorney to be effective, it needs to be signed by the principal and signed by two witnesses. But this document is so important that it also has to be notarized, so signed by a notary. And the reason it has to go through all of this is that again, like I stated before, once you establish a power of attorney document, that person that you establish as your agent, in essence, can do everything that you can do with your financial transactions. So that concludes everything about powers of attorney. If there are no questions about powers of attorney, I will move on to the advanced medical directive. Actually, I'm reading the question right now. What happens when you have a will and you revise it, but the attorney did not make the revision, and you die before it is recorded? So what happens in that instance is whatever the will prior to whatever you revised is what's going to be in effect, because it's just like any other contract. If you create a contract, but if it's not consummated properly, then it doesn't exist. So whatever that was properly existed before is what the law will go by. So the law will go by whatever will that was established prior to this attorney not creating or not updating the will. Okay, so I'm going to move on to advanced medical directives, which is another term for living will that a lot of us use. We use the term living will. And the advanced medical directive is a very important document as well, because it really tells, and it pretty much in advance, it lets people know what you want to do should you become incapacitated, what you want to see happen should you become incapacitated. So it lets people know your healthcare wishes, or it'll establish another person to become your healthcare agent and make decisions on your behalf should you become incapacitated. So it can direct life prolonging procedures should that be an issue for you. And again, it names an agent to make healthcare decisions for you should you become incapacitated. And all these decisions are being done in advance or being made in advance. So it sets forth the healthcare decisions that are to be made. It also directs organ donation decisions as well. And as I stated, I talked about in the will section about funeral provisions. I recommend people put funeral provisions in an advanced medical directive because that document is actually a living document. And so it is readily available, and somebody can readily access that document should that person pass away, and then they'll know the funeral provisions up front. So incapacity, again, this advanced medical directive governs what happens should you become incapacitated. And so I'm gonna just read off what incapacity or incapacitation actually is. A person is deemed incapable of making an informed decision when that person is unable to understand the nature, extent, and probable consequences of a proposed medical decision, or that person is unable to make a rational evaluation of the risks and benefits of a proposed medical decision, or that person is unable to communicate such understandings in any way. So that this document is so important because it establishes what we want to see happen prior to any situation that puts us in a state of incapacity. And it's so important as well because sometimes doctors can't agree on whether somebody's incapacitated. So if we have this document put in place in advance, then we don't have to worry about what should happen should we become incapacitated or should we be deemed incapacitated. And so an advanced medical directive has to be signed by the principal and by two witnesses. And I'm just going to read off what the law says about what the doctors must do. The law says that doctors must do everything medically feasible to keep a patient alive unless that patient has proof dictating otherwise. I'm going to read that again because of what comes next. The law says that doctors must do everything medically feasible to keep a patient alive unless that patient has proof dictating otherwise. So it was a noteworthy situation that occurred here in, I think it was in Florida, a few years back, where Terry Schiavo, she was 26 years old when she went into into cardiac arrest, which left her in an irreversible vegetative state. And her husband argued with her family members that she would not like to be kept alive like this. She would not like to be placed on life support and kept alive like this. However, her family members argued that she would like to be kept alive like this. And so the doctors, they had all they could do is go by the law. And the law again says that the doctors must do everything medically feasible to keep a person alive unless there's documentation otherwise. And Ms. Shavo didn't have this documentation in place. So they had to keep her on life support for a number of years. In fact, she was on life support for 15 years until finally the courts decided that she could be taken off of life support. So I'm not saying that you all or anybody would or would not like to be living in an irreversible vegetative state for 15 years, but I am saying that you do have the power and the control to make sure that you determine how you would like to live should that situation occur. And you can do that in advance. And if you don't do it in advance, it will lead to others making that decision, and it might not be the decision that you would like to see happen. So that would conclude everything I had to say about advanced medical directives. And so I will just move on to speak about trusts. And I'm going to speak just briefly. Actually, I'm looking at questions people ask. As a practicing attorney, what are your thoughts on services such as LegalZoom? I don't know much about LegalZoom. I know that they like contract with attorneys and allow attorneys to review certain documents, I think. However, I don't think you have an attorney that is specifically assigned to you. So in that instance, I don't think that you will get the proper attention should something go wrong. I think everything is okay if everything goes right, but if it goes wrong, then there might be a problem because you don't have the person or the entity or the individual that you don't have an individual working with you. You may have a group of individuals that are working on your behalf. Beyond that, I don't know much more about LegalZoom. I know that they provide like these canned documents. I'm not sure. I haven't examined these documents. So I'm not sure much about what LegalZoom does outside of what my understanding was that I just stated. So another question: what is the best method or process to end the rights of power of attorney from an irresponsible sibling? So, power of attorney can be revoked by the principal. And so what should happen is a revocation of the power of attorney should be drafted and filed. And then that will revoke that irresponsible siblings' rights from their power of attorney. So that's what should occur in that instance. Okay, so trust. I know a lot of people hear a lot about trust, and it might seem like it's a very daunting or some kind of mystique around surrounding a trust, but a trust only is a document that designates a particular piece of property to go to a particular person when a particular condition occurs. So an example is designate I want to give my nephew $20 when my nephew reaches the age of 18. And so, in that instance, or in the instance of creation of a trust, you have what's known as a trustee. So, in my example with my nephew, the trustee would be the person that controls the money that's set aside for my nephew. So, the trustee will be the person that's responsible for creating a bank account and putting that $20 in that bank account so that my nephew, I mean, set aside for my nephew until my nephew reaches the age of 18. And in a beneficiary, the beneficiary is the person for whom the property is to be given. So in my example, my nephew will be the beneficiary of the property in trust. And the property in trust is held in an account or bank account, or if it's real property, then deeds are updated to state that the property is now owned by the trust. And then once the condition occurs, the property transfers to that beneficiary. So when my nephew reaches the age of 18, he now receives the $20 that I set aside for him. He'll probably be mad at me because $20 will not take him too far in 2022, however. So that pretty much ends my discussion about trusts. So I'll move on to myths that I hear. I'll try and dispel some myths that people have about estate planning. So again, we've discussed the three main documents in estate planning, which are wills, powers of attorney, and advanced medical directive. These documents govern maybe 95% of most people's estate planning issues. But one of the myths people have is I don't have any property or money, so I don't need a will. However, as I stated earlier, a will also makes designations of guardianship, and it also designates a person to be a personal representative. And that becomes important when financial transactions must take place after a person passes away, such as a person might be receiving money or a person might be receiving property. And those transactions still need to take place, but they can't take place if we don't have, they can only take place if an estate is open. And so a personal representative needs to be the person that opens an estate in that person's name. My spouse is automatically my power of attorney. That is a very big misconception, and a lot of people believe that. However, there's no such thing as a default power of attorney. Many times there's a lot of people that are spouses that don't even talk to one another, don't even like one another, and the banks don't know that. So there is no, they can't go by the fact that just because somebody's married, they are having I guess a cordial situation, or they have an agreement upon how financial transactions should be taken. So there is no such thing as a default power of attorney. If it's not in writing, it does not exist. Another myth I hear. I already told everybody what my wishes are, so I don't need an estate plan. However, so we are all human, and human beings' memories fade, and so, or human beings might not hear everything the way that you stated it. So you might have said I wanted to give $100 to Gregory Dash, but Gregory Dash heard she wanted to give me $1 million. So it's best to have that in writing so that there is no misconception or any confusion. Another misconception is I already set up a trust, so I don't need an estate plan. A trust, as I stated before, only governs a particular property for a particular person when a particular condition occurs. So it doesn't cover, or it may not necessarily cover, every aspect or every piece of property that we own. And also, a trust also does not govern or consider or make provisions for guardianship of our minor children. So we still need other estate planning documents in place. I don't want to do this because the state will take care of my property, and you are correct. The state will take care of your property. However, as I stated earlier, many of us are accumulating wealth. Some of us are first generation accumulating wealth, and so we've worked extremely hard, and we don't want to let that wealth go by the wayside with when we could have just put these estate planning documents in place. And again, it's all about control. So you lose control by letting the state take care of it when you have the power to control what happens to your property, your yourself, and your children. Another one is I can do it myself, and yes, you can do it yourself. So like you can represent yourself in any aspect of law, including you can go to court and represent yourself for a criminal case. However, you'll be up against a state's attorney or another attorney that has gone to law school and has passed the bar exam, so it might not go in your favor. Also, so with the state planning documents, if these documents are not drafted properly and correctly, they could be deemed invalid, and so this could again lead to your property not being disposed of in the manner that you would like to have it, or your children not being taken care of in the manner that you would like to have it. And again, right now you have the power to control that. Another one is we have a joint bank account, so I don't need a power of attorney. Again, that joint bank account, even if you have joint bank accounts, that only governs that one particular piece of property or bank account. A power of attorney gives another person the access or the power to access all your accounts and take care of financial transactions of all of your accounts, which could be helpful for you, or which more than likely would be helpful for you. Another one is I already told my family members that they are the godparents of my children. That's a big misconception. Again, a lot of us in our community say we're godparents. That's my godfather, and all that. None of that means anything unless it's in writing. And none of that means anything in the eyes of the law unless it's done in writing. My family member became incapacitated, so now I need a power of attorney. As I stated earlier, it's too late. A person has to be coherent and cannot be incapacitated in order to establish a power of attorney. Another one is my family member passed away but told me their wishes. Now I can establish a will. Of course, that can't be done. It has to be done for a person that's coherent and actually a living person as well. Right. I had another one in my mind, but I just forgot it. Okay. So when do these documents need to be updated, or when are these documents needed? So when a person reaches the age of 18 is when these documents should be established, again because they follow contract law, and a contract is void or voidable for a person that's under the age of 18. When a person gets divorced, these estate planning documents need to be updated to change the spouse as beneficiary if that's what the person wants to see happen. If a child is born, your estate planning documents need to be updated to add that person as a beneficiary. However, when I create these estate planning documents, they are created for in perpetuity, meaning that they already cover what happens if a person accumulates more property, or if a person has children, or adopts children thereafter, so that you don't have to continue to update these documents for two reasons. One, because it costs money to update these documents. I try and save people money, but also, stuff happens. You may not get back to an attorney to go back and update these documents. So if it's already done in consideration of what might happen in the future, then you don't have to worry about that. So if new property is purchased at times, those estate planning documents need to be updated as well. In the instance, so we have unclaimed property. A lot of people have passed away, and they don't know that the state has property in their name. They own property that they don't know anything about. Well, in order for someone else to access that property now that that person passed away, an estate needs to be open. And in order to open an estate, the personal representative will be the person that will open an estate in the name of the deceased person. Another situation. So when you plan to set aside money for a child's education, You can establish a trust or other estate planning documents to provide for that. The death of a beneficiary. So when a beneficiary passes away, these estate planning documents may need to be updated to change the beneficiaries to other people, especially in like life insurance policies and those types of policies as well. Oftentimes, though, if a person passes away, a beneficiary passes away prior to the testator, then the the funds or property that was going to go to that person is transferred to that person's estate. A change in health, if your health changes, you need to update your estate planning documents to make sure that you have a power of attorney in place and advanced medical directive in place as well. Same for impending medical procedures. Those two documents need to be created or updated if necessary. So again, these documents are all about control. It's all about control. And when you don't put these documents in place, you give up control. And there's very few things on this earth that we have control over. I mean, we can't even, some of us can't even control our offspring at times. So estate planning is an area of law that you have absolute control of for the most part. You can control the disposition of your property, your yourself and your children. And so you give up the control that you have by not putting these documents in place. And once you give up this control, you leave it up to somebody else. And once you do that, it may not go in the way that you would like to see it be transpire. So it's just important, and it's not very cumbersome. It's not a cumbersome process. It's not a long process. It doesn't have to be a long, drawn-out process. A will can be as simple as saying, I give all my property to my brother, or it can be as complex as saying, I give my 1998 Tuskegee ring to my nephew, and it can be that drawn out, or it can be as general as I stated before. And all these other documents, they are very like simple documents to put in place. And once these documents are in place, it can eliminate so much confusion and problems with not only with the law, but just within families. I'm telling you, I hope you all can see I have a lot of passion for this. If you saw me in person, you would see it. But anyway, a lot of people come to me about estate planning, and it's causing so many problems within their families. I have these people right now arguing over a house that's worth probably about $80,000. It's 8 siblings. That one of them passed away. That she passed away without a will. So the rest of these siblings are arguing over the value of this house, and I mean, they just talk really badly about one another, just about a house that, like I said, is worth $80,000. And these people are 80 to 90 years old. So it just baffles my mind. I never seen stuff like this until I started working in estate planning. So please, please, please get these documents put in place. And just to recap everything, again, passing away is inevitable, but control and preparation are the key. But again, this is not all about doom and gloom. As again, many of us are accumulating wealth. We are starting to accumulate wealth or have accumulated wealth throughout our lives. And so we want to ensure that we control the proper transition of our legacy. And so you take control of this by putting these estate planning documents in place. You take control of the disposition of your property, yourself, and your minor children while you're here and when we transition. And again, I can be reached at g-at-lawfirm.com. My law firm is Dash Law Firm, and my website is www.dashlawfirm.com. Cell phone 443-622-6523. I can be reached by text, phone, anytime. And again, just to recap or restate, this is not legal advice. This has not been legal advice. It's just information about estate planning. And I just hope and wish that you all take this very seriously and get this done, because it's causing a lot of problems within our families. And I just see another question someone asked. If someone tries and write a will from their hospital bed 2 days before they die and the will is not executed, is it not valid? So if you say if it's not executed, in order for a will to be properly established, it has to be signed by the person that, or by the testator, and witnessed by two signatures. So if that didn't occur, then it's not a proper will. Another question. I recently saw some information on how Black Americans are missing out on a $68 trillion wealth transfer. From well, yeah. So what's happening is a lot of our people are not putting these estate planning documents in place, and so oftentimes we have property, or we have a person owns property that's very valuable, but they haven't established estate planning documents. And so they haven't established a person to be a beneficiary of that property, or they haven't designated that property to transfer to someone else. And so what happens is the siblings get into an argument of I'm not paying the taxes on this property. And so nobody wants to pay the taxes on the property. And what ends up happening is in many states, after even a year, if the taxes aren't paid, it goes into a tax sale, and some other entity goes and buys that property for what, pennies on a dollar. And so that property just goes away without and it goes out of the family, and it could just be, this could be taken care of so easily if we put these estate planning documents in place. So that's one of the main ways as to how this $68 trillion is leaving, because many of us are not putting these documents in place, and so a lot of property is being just taken away, and tax sales is one of the main reasons. Yes. Okay. And so that's pretty much all the questions that people have had. I'm so glad that you all tuned in to hear me speak about estate planning. Again, this is a topic that's very near and dear to me, and I think it's the most important topic in law. You know, like I said, I deal in family law, I deal with criminal law as well. But you know, this generation, wealth is very important in America, and so if we don't transition this wealth, even while we're alive, if we don't put these documents in place, take care of this wealth that we are accumulating, then you know our lives, a lot of our the work that we put together in our lives is going for naught. You know, and somebody can just easily come by and get this wealth for nothing, for little of nothing. Oh, I have another question that I just received. If a spouse's name is not listed as the beneficiary, can they go into litigation to receive the assets? If a spouse's name is not listed as the beneficiary, can they go into litigation to receive the assets? Yes, they can go into litigation to receive the assets. But the problem would be, though, if somebody else is designated as the beneficiary of some of property that the spouse feels as though they should receive. It's a hard sell to the court to explain why the spouse should receive it instead of the person that's designated in the will. So yes, you can go into litigation. You actually can go into litigation about all of this. However, it's hard sell once it's in writing. So once it's in a will, it's hard to overcome what's written in the will. Is it recommended that more than one person be named on a power of attorney document? I always recommend against putting more than one person down as an agent for a person, because oftentimes two people do not agree on everything, and so that can cause a lot of problems. That can cause a lot of problems. I would instead recommend that people make another person a backup. You can make a backup agent in case the primary agent either does not want to or is not able to carry out those provisions. What happens if the power of attorney is effective immediately and the person in charge wants to take over assets while the owner of the assets is still able to function? That's why there needs to be the person that you designate as your agent needs to be a very trustworthy and a very responsible person, because yes, that person can perform any financial transactions that you can perform. So in that situation, is pretty much the first person that makes the transaction is the one uh that's going to hold. And to reverse that will take a lot of effort with the courts. Companies that do gift matching, even though you don't work for them. I'm sure there are. I'm not. You mean gift matching? Oh, as far as like so if you put in your will that you want to to uh to leave a certain amount of money to a certain entity, there are companies that match those gifts as well. I know. I shouldn't say I know. I think Lockheed Martin is one, but I'm not sure of all the companies that do that though. But there are companies that do matching. Okay. And I think that's all the questions that I have received from everybody. Again, I appreciate you all tuning in. Again, I don't care how you get this done, just please get these estate planning documents put in place, because it's causing a lot of problems in our community. And again, thank you all for tuning in.